So, first, thank you all for joining us today, this afternoon, for the Fair Housing Center of Southwest Michigan's Keys to Fair Housing. My name is Derek. I am our fair housing educator. Uh, I'm a white guy with a red mustache, and I will be your presenter today. So, before we get into things, I'd like to make a brief acknowledgement to Mishta. Um, it is because of a generous grant from Mishta that we're able to offer these trainings free of charge. Uh, Also, just a little housekeeping here. We are not attorneys. And so all of the information in today's training is presented for educational purposes only. It's not legal advice. Uh, and this session is being recorded. So I ask that if you have questions, please put them into the Q&A box, and I will take some time at the end of the presentation to answer as many as I can. For those of you who don't know the Fair Housing Center of Southwest Michigan, we serve Allegan, Berry, Berrien, Branch, Calhoun, Cass, Kalamazoo, St. Joseph, and Van Buren counties. These are the 9 counties of Southwest Michigan, and we work to promote integration and to eliminate housing discrimination through education, advocacy, and enforcement of the Fair Housing Law. And we order those tools intentionally. The Office of Housing and Urban Development, or HUD, estimates that each year there are at least 4 million occurrences of housing discrimination, and of those, only about 11,000 are reported. And so we figure that if we educate well enough, we ideally can eliminate housing discrimination before it begins by uh, instructing housing providers. Uh, we also believe that education can encourage people to recognize and report the discrimination that they may be going through. And after that, we can help to advocate on their behalf and work to secure justice through the enforcement of the Fair Housing Law. And finally, through our efforts and successes in that enforcement, we learn how best to redouble and redirect our educational programs so that we can maximize effect. And so, what is fair housing? Fair housing is the right to equitable access to housing and all services involved in the housing transaction. So, this includes renting, buying or selling, putting up advertisements for available housing, financing a home, insuring a home, appraising a home that you already own. Um, and we like to say that where you live affects how you live. Of course, the goal of this session is to give you information to help protect yourselves and the members of your communities. Um, Much of this training is designed around the tenant's perspective and acknowledging their rights. Um, However, it is important that housing providers also understand the fair housing laws and their responsibilities therein. Of course, today you don't have to memorize everything or come out of this as fair housing experts. Any questions you have, you can always call us at the Fair Housing Center. There will be some contact information at the end. With any questions, concerns, fair housing complaints, we'll be happy to help. So, fair housing is the right to equitable access to housing. But what it also, another way to put that is it's the right to be free from housing discrimination in the housing transaction. And there are 3 elements to determining whether something is housing discrimination. Uh, it needs to occur in a covered dwelling, and that is to say, or rather, very nearly all residential constructions are covered by fair housing. The person at issue needs to be a protected person. So, federally, there are 7 protected classes: race, color, religion, national origin, sex, family status, and disability status. State and local governments can add to, but never remove those protections. And each of these protections was won over time, and we'll cover the laws and acts that built these into law um, in more depth in just a moment. And finally, an unlawful practice needs to be involved. And so that is any practice that treats differently any member of a protected class during any part of the housing transaction, whether through intention or effect. And again, we'll get to that here in just a moment. So, what are the covered dwellings? Um, Covered housing or dwellings under the fair housing law, we like to take as broad of a construction as possible. So there, with very limited exceptions, all places of residence that are not strictly commercial ventures, like a hotel or a motel, are covered by the Fair Housing Act and its associated civil rights laws. And further, all aspects of a housing transaction are covered. So not only does the Fair Housing Act prohibit kicking a person out of their rented apartment based on their nation of origin, it'll protect that same person from similar discrimination in the rental application process, in the process of securing a loan, in the appraisal of the home, etc. There is an edge case that comes up in certain mixed use dwellings, such as Airbnbs or long term hotel stays. And how the fair housing law applies to those is largely based on whether or not a primary residence exists. So, for instance, in the case of hotels, fair housing will seldom apply because a guest in a hotel usually has a primary residence elsewhere. Uh, in the case of shelters for the unhoused, however, despite the stay sometimes being as short or shorter than a hotel stay, fair housing usually does apply because no other primary residence exists. And so this list is an incomplete um, list of those places where fair housing law applies. And I'd like to make note of housing construction sites, homeowners associations, public housing authorities. These aren't the dwellings themselves. They are places where the housing transaction may occur. And these, of course, are also covered by fair housing. I noted that there were limited exemptions, and those are the religious organization exemptions, the Mrs. Murphy rule, or a small holding or owner occupied housing exemption, and then finally senior designated housing, and that includes housing designated under the Housing for Older Persons Act or HOPA. So, in limited circumstances, pardon me, the Fair Housing Act will make exemptions for housing operated by religious organizations. So religious organizations are allowed to give preference to people of the same religion if the housing is non-commercial and the religion itself doesn't discriminate based on other protected classes. So, for example, a Catholic organization can legally limit occupancy or give preference to Catholics if it leases apartments at a property and then doesn't charge those residents rent. The Mrs. Murphy rule, as it's known, exempt small holding housing owners from the fair housing laws. So federally, uh, this rule is that a residence that comprises 4 or fewer units in which the owner of those residents presently lives, um, that residence is exempt from fair housing under this rule. Each state has its particular version of the Mrs. Murphy rule, and Michigan's mirrors the federal rule while restricting the residence to 2 or fewer units. This rule was built into fair housing nominally to protect an owner's First Amendment rights of freedom of association. And then in housing meant for older persons, this has, there are two ways that this breaks down: housing for persons 55 and older, and housing for persons 62 and older. And these have some quick rules that delineate them. In housing meant for people 55 and older, 80% of units need to be occupied by at least one person who is at least 55 years old or older. And the terms, regulations, and advertisements of that building or that dwelling must clearly state its intent to operate as housing for people 55 years old or older. And for persons 62 years old or older, those same rules apply, except that it's also true that 100% of the units need to be occupied by at least one resident of that age. So usually, disabled people can live in either class of dwelling, regardless of their age. And in both cases, some further exemptions exist that will allow caretakers or full time employees of the dwelling to live there regardless of their age. And even with these limited exemption cases, it's never permissible to discriminate outside of those protected classes that are exempted. So, in the case of religious organizations, you can't advertise that you would prefer, uh, you know, uh, U.S. People born in the United States to live there. That would be national origin discrimination. Uh, so, these protected classes, as I said, there are 7 protected classes federally. And here in Michigan, this lists 4. There are more than that. Um, the protected classes federally are presented here in blue. No state can limit these protections, but states and municipalities can add to them. Pardon me. So here in Michigan, the additional protected classes that apply most to housing are age and marital status, as well as sexual orientation and gender identity. The controlling Michigan civil rights laws list more than just age and marital status as protected classes, but these extra protections apply usually to cases of employment instead of housing. So, for instance, although weight is a protected class under Michigan civil rights law, weight discrimination is usually not an issue in fair housing cases. Uh, and the most recent protected class in Michigan, source of income, was signed into law late in 2024. Um, Here, a brief note on language. I'll use both protected class and protected characteristic to refer to these 7 federal protected classes and 4 plus protected classes in Michigan. This is just for the sake of uh, fluency. You know, sometimes it can be a little more awkward to describe someone as being in the class of families with children, other than saying that their characteristic of being in families with children is protected. So, for the purposes of today, protected class and protected characteristic refer to the protected classes. And so, race includes all races. Color refers to the color of one's skin. A darker skinned person of Indian origin has the same rights as one with lighter skin. Religion includes one's membership or lack thereof in an organized religious group, as well as one's spiritual ideas or beliefs. National origin refers to the country where a person was born or from where their ancestors came. Sexual orientation and gender identity pertains to one's actual or perceived sexual orientation, as well as the identity, expression, or perception thereof. This includes one's relevant attitudes, preferences, beliefs, and practices of their gender, irrespective of their relation to their sex assigned at birth. And you'll notice that the federally protected classes include only sex, whereas Michigan's protects sexual orientation and gender identity, um, meaning that federally, only one sex assigned at birth is a protected characteristic. Family status indicates the presence of one or more children under 18 in a household that maintain a custodial relationship with an adult. So this includes parents, step parents, adoptive parents, guardians, foster parents, a pregnant person, or someone who's in the process of acquiring legal custody of a child. Disability. This is the most cited case, or excuse me, most cited protected class in fair housing complaints. And we'll get into it in a bit more detail at the end of this towards the end of this presentation. Um, Marital status protects single, married, separated, engaged, widowed, divorced, and in some jurisdictions, simply cohabitating. Um, Age means individuals of any age, and source of income means that a person who is seeking housing or living in a can't be turned away if part of their income comes from, for instance, supplemental security income, Section 8 vouchers, anything that's not a traditional career based. Uh, and these classes, as I mentioned, are protected by specific laws. So we're going to look now at a brief timeline of those laws. We begin in the top left with the Civil Rights Act of 1866, and we move down to various executive orders. These come out as they come out federally. And in Michigan, the Elliott Larson Civil Rights Act of 1975 is the controlling Civil Rights Act here in Michigan. And the latest edition was the Senate Bill 205 package in late 2024. So, with the Civil Rights Act of 1866, this was passed shortly after the end of the Civil War and the ratification of Amendments 13 and 14. And it details primarily the economic and property rights of the newly made citizens, that being newly freed slaves and otherwise anybody born on American soil, including explicit protections against abridging those rights on the basis of race or color. Uh, the Civil Rights Act of 1968, Title 8 of which is known as the Fair Housing Act, came during civil rights movement. Um, the pressure generated from organizations such as the NAACP and the GI Forum, um, who were fighting for housing representation while members of their family were fighting and dying overseas in Vietnam, was a major part of the pressure generated, especially from the GI Forum, as well as the intense pressure generated by the assassination of Martin Luther King Jr. and the subsequent riots in more than 100 US cities. All these things culminated in forcing President Lyndon Baines Johnson into signing the Civil Rights Act of 1968. And this act established race, color, national origin, and religion as protected classes in housing transactions. Oh, apologies. The Fair Housing Act would see a couple of amendments. First in 1974 to add sex as a protected class, and then again in 1988 to add family and disability as protected classes. In 2021, Executive Order 13988 elaborated on the protected class of sex to explicitly include protections for all sexual orientations and gender identities. Um, a later executive order, which I'll get to on the next slide, changes this. And alongside the federal fair housing laws, again, state and local governments pass their own fair housing laws, and those laws can only expand and never curtail the protections afforded by federal law. And so here in Michigan, the Elliott Larson Civil Rights Act, ELCRA or ELCRA, um, adds marital status and age protections in 1975, alongside a whole host of other mostly employment related civil rights protections. And then finally, on December 30th, 2024, Michigan Governor Gretchen Whitmer signed into law Senate Bill 205, which was the most salient among a package of, I believe, 5 bills. And this added fair housing protections based on sources. Like I said, some recent changes as of January 20th, 2025. Um, Federal sex protections no longer include sexual orientation and gender identity. Michigan law has not uh, moved to mirror the federal law as yet. And here at the center, we'll work to provide information on these changes as they occur. And once again, if you have questions about whether or not a change may have occurred, please feel free to contact us. And we'll do our best to get you good information. By adding source of income protections here in Michigan, a landlord cannot discriminate if a tenant's income includes Section 8 housing choice vouchers, public assistance, veterans benefits, Social Security, supplemental security income, or other retirement programs. As long as the income is legally obtained, it can be used in determining what sort of bracket of housing you can afford. The package of legislation also defines source of income within the Elliott Larson Civil Rights Act and provides methods by which tenants can file complaints with the Michigan Department of Civil Rights. So that is the covered dwellings, the protected classes, and we're about to get into the uh, illegal behaviors, illegal housing practices, but these come in 4 basic flavors. Uh, First is discriminatory intent. This is the most obvious. If a person is acting actively racist toward a tenant, that's discriminatory intent. Disparate impact is a slightly more subtle, and this is a passive or facially neutral action that mistreats a protected class just by how this intersects with reality. Retaliation is negative action taken after a person asserts their fair housing rights. And then finally, failure to accommodate has primarily to do with those living with disabilities. We'll be talking more about this here in toward the end of the presentation, but this is neglecting to allow reasonable accommodations or modifications that will better allow a person full use and enjoyment of their dwelling. Now, the star there at disparate impact, this is another one of those recent changes. Federally, disparate impact is to be ignored as an angle of investigation in federal civil rights cases. Um, but because it's still valid here in the state of Michigan, in order to explain it, I like the following hypothetical. So let's say that a property developer wants to build affordable housing that is specifically intended for occupation by area nurses. Career is not a protected class, so this seems initially above board and may even be construed as noble given the profession. However, as the facts bear out, in the developer's area, 95% of nurses are white. So, by attempting to limit access to the dwelling only to the area's nurses, the developer has also unintentionally limited access based on race, which creates a disparate impact. And then, one more note on retaliation. Even when a complaint does not constitute an example of legal housing discrimination, retaliation. So, if after someone brings that up to a fair housing center, to the Michigan Department of Civil Rights, if the landlord then raises the rent or withholds maintenance, that retaliation now does constitute a violation of the Fair Housing Act. So these are the forms of discrimination. Let's look now at some of the more common ways that we see them. And so while this list again is not exhaustive and doesn't capture uh, every way that you'll see a fair housing violation, usually they come in four flavors, uh, excluding failure to accommodate, which is sort of on its own. You'll have terms and conditions discrimination. You'll have steering, misrepresenting availability, and then discriminatory statements. So we're going to walk through these one by one. So a terms and condition discrimination, it's unlawful to offer or impose different terms and conditions based on a protected class. So even when these terms and conditions may be seen by the person offering or imposing them as being beneficial, the different treatment is in itself discriminatory. Pardon me. So let's say a prospective tenant who is white is given access to a portal showing all available rentals, but a prospective black tenant is not. This is terms and conditions discrimination based on the protected characteristic of race. Um, why isn't one tenant getting access to the full slate of rentals? If a tenant is asked to submit rent online after, say, a Michigan based housing provider learns that that tenant is gay, while a person who isn't gay is still invited to pay at the office, that's terms and conditions discrimination based on sexual orientation. And here, this person would be able to file a claim only with the Michigan Department of Civil Rights, which, because it's a state organization, they would not have recourse through housing and urban development because it's federal. And that's due to the changes we discussed earlier. If a landlord wants to charge a person with an apparent disability a higher security deposit, my goodness, say in anticipation that they'll need grab bars or some other reasonable modification installed, even if the tenant does end up needing that modification and the cost is paid out of that higher security deposit, the the fact that that's a difference that's imposed also constitutes terms and conditions discrimination based on disability. And then finally, let's say that a landlord routinely sorts maintenance requests from women who live in the complex to the bottom of the stack. This would be terms and conditions discrimination as well. Next, we have steering. And steering is broadly defined. It can be very wide or quite narrow in scope. So, for instance, in the past, many local governments would have laws specifically forbidding integrated neighborhoods. So, these laws would prohibit Black people from moving into majority white neighborhoods and vice versa. Um, this is an issue in a controlling piece of Supreme Court legislation called Buchanan v. Worley that is interesting. And if you'd like to learn more, good place to start. But at any rate, that could be in effect considered to be steering at its largest scale. So at a smaller scale and with less obviously cruel intentions, a common practice such as pushing prospective tenants to the rear, prospective tenants who have families to the rear of an apartment complex because, lots of families live there. Or that's where the playground is, or we have elderly residents up front who complain about noise in this other area. Any reason given, uh, that is steering and prohibited by fair housing law. Some other examples include suggesting to a Spanish speaking home seeker that they might prefer this particular neighborhood because it has a church that holds Spanish language mass, uh, not renting second floor apartments to somebody with a mobility impairment. Um, of course, this is also subject to accessibility and accommodation requirements. If that building has an elevator, there's no reason that someone shouldn't be able to live on the second floor, for instance. We'll move now into misrepresenting availability. This feels very similar to steering in that it has the effect of pushing people to certain zones, steering or segregating them. It's subtly different in that the housing isn't made available in the first place. And it is what it sounds like. It's telling people that there are not units available when in fact there are. And this can be a difficult type of discrimination to identify, as finding out that that unit was actually available often happens by either accident or focused investigation. And so, as a reminder here, it also must be shown in these cases that the misrepresentation is related to a person's protected characteristics. Not showing someone apartments outside of their price range is not a misrepresentation of availability, unless um, here in the state of Michigan, that prospective tenant is only shown apartments that fit their income without supplemental income, such as Section 8. That would be illegal misrepresentation of availability because source of income is protected in Michigan. And so finally, we have discriminatory statements. They may be the most recognizable type of discrimination. They're not always slurs or violent speeches. Um, it's sort of related to terms and conditions here. Something as innocuous as having a sign at pool in the common area or a sign in a weight room that children must be accompanied by adults. That can be construed as a fair housing violation based on family status. And so instead of having something like children must be accompanied by an adult at the pool, you know, a sign that says no lifeguard on duty, swim at your own risk, avoids anything that might single out a protected class. Um, it doesn't have to relate directly to the housing relationship. So that's your landlord does not need to say that I can't have whatever racial slur living here. If they're just using racial slurs and they're your landlord, you may have grounds for a fair housing complaint. And then finally, this example phrase, I can't stand magicians. This could be a quirk of the housing provider, entirely unrelated to fair housing. But if they have a tenant who happens to be black and also happens to work as a magician, it can be reasonably interpreted that this is not only about the tenant's job. And this is especially true if one can identify a timeline. So, did the landlord ever discuss this opinion before that particular tenant moved into the building? So these are common types of illegal housing practices. They could be related to any of the protected classes. Uh, and like I said, the failure to accommodate has mostly to do with people who live with a disability. And we'll move now into a discussion on disability, which is the most cited protected class in fair housing. So, first, let's define under the law what is a disability. Um, a disability under the law is an impairment that substantially limits a major life activity. And a person with a disability does not necessarily need to be disabled for these laws to apply. That is, a person is protected with regards to their disability if they actively live with that impairment, uh, if they are perceived as having such an impairment, someone who has a history of having had such an impairment, and even the people, if someone associates with someone who falls under any of these definitions of of disability, that association is also protected under the Fair Housing. And so, next, what do we mean by major life activity? A major life activity is to be construed as broadly as possible. It's any impairment which limits or substantially changes by, for instance, requiring the use of a wheelchair or a white cane. Um, any impairment that limits these major life activities can be considered a disability. So these are life activities like sleeping, walking, talking, working, driving, uh, cleaning. Uh, Disabilities are sometimes apparent, and quite often they are not. And under fair housing law, all people have the right to full use and enjoyment of their home. Sometimes a person's disability may require that changes to either the rules or physical space of a dwelling be carried out in order to achieve that full use and enjoyment. And that apparent non apparent split is important to the process one may have to go through in order to secure those changes. And that brings us to failure to accommodate. This has to do with reasonable accommodations and reasonable modifications. As of March 13th, 1991, a few years after the signing of the Fair Housing Amendments Act of 1988, all new multifamily dwellings um, constructed for first occupancy after March 13th, 1991 needed to be designed with accessibility in mind. And of course, not all new constructions are multifamily. Not every dwelling occupied by a disabled person is a post 1991 construction. So that accessibility then is accomplished through reasonable accommodations, which are changes to rules, and reasonable modifications, which are changes to a space. Refusing to allow these accommodations and or modifications is that failure to accommodate, which is a violation of the Fair Housing Law. So, as I've mentioned, individuals with a disability are entitled to the full use and enjoyment of a dwelling, and these changes may be necessary to achieve that. So we'll talk first about reasonable accommodations, then modifications, and then what constitutes reasonability. So accommodations, reasonable accommodations, are changes to the rules, policies, procedures um, on how services are provided or how a person has access to these services. It's a broad concept. What's needed and how it is provided depends on the circumstances of a person. Um, Crucially, it's the responsibility of the person who is living with that disability to request the accommodation. Um, Simply put, they know their needs best. And the idea, again, is to assist that tenant in achieving full use and enjoyment of the dwelling, but without placing an undue burden on the housing provider. There are a number of rules and laws that govern what constitutes a truly accessible construction. Not all of them are necessary in, say, a single family house in which one disabled person lives. So let's say that this person has a mobility impairment that does not necessarily require the use of a wheelchair. What they may require is a is just a ramp, but not widened doorways. Um, One of these multifamily dwellings after 1991 would be required to have both. Uh, so when are reasonable accommodations? So if we consider again the distinction between apparent and non-apparent disabilities, it's unfortunate but often true that non-apparent disabilities can be treated with more suspicion by housing providers. Uh, the need for a wheelchair, say, is easier to prove to an outside observer than the need for an animal that helps someone manage their post-traumatic stress disorder, for instance. So again, these reasonable accommodations are needed when the person with a disability asks for them. The reasonable accommodation helps them to achieve full use and enjoyment of the dwelling. And the reasonable accommodation does not constitute an undue burden on the housing provider. There's no standard catalog of accommodations that people may need, as everybody is unique and has unique needs. And for that reason, it is the responsibility of a housing provider to listen to reasonable accommodation and modification requests in good faith, and to not assume what a person may or may not need, and also to enter into what's called the interactive process, which is that if uh, if it's determined by a housing provider or suggested by a housing provider that the requested accommodation is unreasonable, it's their responsibility to suggest an accommodation that may also work. And then to have that dialogue ongoing and in good faith so that both parties can reach um, a compromise that, again, crucially allows the person living with a disability full use and enjoyment. So, what are some examples? Um, we see some of these pretty commonly in fair housing. For instance, mailing rent instead of paying in person. It may be appropriate to permit a tenant with a mobility impairment not to come into the office to pay that rent. Um, in cases where a rental agreement doesn't allow overnight guests, it might be reasonable to permit tenants um, who need them, to permit tenants who have disabilities to have a 24-hour personal care assistant who can stay in their apartment with them. In many, but not all jurisdictions, that caregiver is not beholden to rent requirements. They're not a tenant, but a worker in that building. And it's sort of like, it would be sort of like charging a maintenance person rent for the hours they spend in an apartment fixing something. Uh, Sometimes the number of ADA or Americans with Disabilities Act required accessible parking spots um, may be insufficient for every tenant who could benefit from them. A reserved parking spot, usually one that lessens the distance or obstacles between the spot and a person's dwelling, can help to alleviate the problems caused by first come, first served parking. Some people with disabilities might have little to no rental history because of non traditional living arrangements. Maybe they lived with relatives, sometimes having lived in a medical institution. Uh, in those cases, it might be appropriate for a housing provider to accept a reference from an employer or a social worker instead of a traditional rental history. And finally, and this is a common one, service and or companion animals are a big example of reasonable accommodations. And so these are accommodations against the no pets policy. Um, a disabled tenant must be allowed to keep a service or companion animal if they can provide proof of need. What's known in the law as a nexus of care needs to be established. So, again, another note on language here. Variously will refer to the animals that help a person with the symptoms of their disability as a service, support, or companion animal. Um, because a person's disability does not exist only within the home, we find it useful to maintain these distinctions while remembering that fair housing laws do not distinguish between service, support, or companion. So the Americans with Disability Act maintains a separate definition for service animals, and those are things such as a seeing eye or leading dog for the visually impaired, and that is specifically to protect their use in public spaces. Now, the Fair Housing Act, because it applies only to one's own home, the distinction there is less relevant. It should be remembered, of course, that the care that can be provided by an emotional support animal is no less important than that provided by a service animal. So, a service dog, as I mentioned, may act as a leader for a visually impaired person. Other service dogs act as stability aids, are trained to open doors, to fetch medicine. Some even smell oncoming seizures. Of course, that list is by no means exhaustive. Uh, Emotional support animals, however, often serve less visible but no less important functions. Things like reducing stress during an anxiety attack, distracting from or halting self destructive behaviors, comforting during PTSD episodes. Again, by no means an exhaustive list. Um, Like I mentioned, all that said, one of the most common accommodations that arises in fair housing is these support animals. When a tenant indicates a need for a service or support animal, the housing provider can, especially in the case of non-apparent disabilities, request that that tenant provide a letter from a healthcare provider verifying that the tenant has a disability which requires the presence of the animal. Courts have ruled that licensing or certification of service animals is not required so long as the tenant demonstrates that the animal provides necessary assistance. And importantly, a housing provider cannot inquire specifically about the disability the person has or the services that the animal provides. Uh, and while many support animals are dogs, they can be any type of animal. Uh, that may change based on jurisdictions, but here in Michigan, that is true. They don't need to wear any special harnesses or tags. There's no special certification or licensing that is required for support animals. And in some cases, an individual with a disability may require more than one support animal. All that's required is that there be that nexus of care between the animal and the disability. Uh, that is, the animal provides some function that alleviates the symptoms of the disability. I believe a question just came in. Again, I will get to those at the end of the report or at the end of the presentation here. Um, these animals, however, are always subject to safety and hygiene standards. So while support animals are a reasonable accommodation in that the housing provider accommodates the tenant by waiving their no pets policy to allow the presence of an animal or animals in the home, sometimes what is needed is not an accommodation, but a modification. And these are alterations to the physical space in which a person lives that may assist the tenant in navigating that space. So something like in grab bars rather that would help with stability, usually in slippery surfaces like a shower, um, something like a ramp to allow wheeled or non-stepped travel, um, assisting in navigating the space, being alerted to changing information in the space. So a modification of flashing lights instead of a doorbell for a hearing impaired person, for example. Um, much as is the case with reasonable accommodations, though, uh, this list that I've said is not, of course, exhaustive, and it's up to the person with an impairment to determine what modifications suit their needs. Um, Other examples of modifications include widened doorways for wheelchair access, zero-step showers instead of a high bathtub wall, reinforcements to the studs of a wall for the installation of that grab bar. Again, not an exhaustive list at all, and up to the person to suggest the modification that would help them. Now, in the case of reasonable accommodations, it's usually very inexpensive, even free to adjust rules and regulations. But if you're going to install a ramp, that requires time, labor, and materials to construct. And all these things have expenses that add up. So who pays for it? Now, generally, in private housing, the tenant is expected to cover the expenses of making reasonable modifications unless those modifications also benefit the whole building. For instance, if the apartment complex didn't have a ramp leading to the pool, the tenant generally would not be expected to cover those expenses. Um, in the case of a reasonable accommodation, the changing the rules to allow that reserved parking spot will cost nothing. But printing and installing the sign that designates that spot as reserved, that has a cost, and the tenant may be required to cover those costs. In the case of housing that's subsidized, whether through Section 8 or perhaps a Rural 515 program, usually the housing provider is required to cover those costs. And with modifications, because they're physical installations, some issues do arise, excuse me. Um, One you'll see is in order to save money on a modification, a tenant may offer to accomplish that modification themselves. They might know a guy or have a family member who can help them build the thing that they need. Um, the housing provider, however, does have the right to insist that the professional install the modification, and that professional can be chosen by the housing. Um, Wear and tear is defined as expected deterioration that occurs over time, which is to say that its dispute is on a case by case basis. Uh, and a tenant may be required to repair the dwelling past wear and tear to its previous state, unless this is a neutral change, which refers to changes that do not impact any later tenant's ability to fully use and enjoy the dwelling. A widened doorway doesn't need to be narrowed at the end of the tenancy. A grab bar and a shower might need to be required to be removed, but if the wall needed reinforcements, that reinforcement does not need to be removed. It doesn't impact any later tenant's ability to properly enjoy and use that space. So we've been saying reasonable accommodation, reasonable modification. What then does reasonable mean? There are situations, of course, where an accommodation that's been requested is not reasonable. Sometimes that request amounts to an undue burden for the housing provider, which means that in the context of the provider's total financial and administrative costs, that accommodation would be too costly. Um, it could also constitute a fundamental alteration of the way that the housing provider does business. Uh, and I think a couple of examples will help clarify that. So, whoops, a unreasonable accommodation, excuse me, may be if we imagine a tenant who has a chemical sensitivity disorder, and they request that the owner survey all the tenants in the building to determine the time and day and the types of chemicals that their neighbors will use to clean their units. Asking the owner to compile that information for them on a weekly basis, and so that they can then plan to be away from their unit at the time certain chemicals are used. That sort of on it, that could constitute an undue administrative burden. Um, uh, a more reasonable accommodation may be having the public areas cleaned with low volatility chemicals that aren't um, so aggressive for folks with chemical sensitivity disorders. An unreasonable modification, for instance, could be requesting the installation of a chairlift where a ramp would suffice. A mechanized lift is often far more expensive. And then excuse me, a fundamental alteration of the provision of housing can be seen if we look at a Housing for Older Persons Act dwelling. Let's say a tenant requests that several of their grandchildren be allowed to live with them. Uh, this invalidates the terms of the program and that it's housing intended for older persons. Um, and just to reiterate, in all cases, when an accommodation or modification is deemed by the housing provider to be unreasonable, it is their duty to work with the tenant to try and find a more reasonable solution. Um, Much like many things, there is a very limited exemption case, and that is the case of direct threat. So in very limited cases, a person's fair housing rights may be abridged if they can be shown to present a direct threat to others. All residents are afforded the right to full use and enjoyment of their dwellings. This exemption is a rarity and must be carefully considered. It needs to take into account the nature, duration, and severity of risk, the probability the injury will occur, and whether or not a reasonable accommodation can limit that risk. Now I'd like to briefly get into just a couple of housing issues that aren't necessarily related to fair housing or uh, just sort of adjacent to fair housing. And the first of these is criminal records. Um, Having a criminal record is not yet a protected characteristic. However, it can and often does intersect with other protected characteristics. And for these purposes, we're talking about the state here because that intersection creates that disparate impact. So, for that probability of disparate impact, or the potential rather for disparate impact, certain approaches to criminal background screening in the tenant application um, are generally disallowed by the fair housing law. For instance, blanket bans on criminal records are usually going to run afoul of fair So there's some pretty simple best practices in approaching criminal records in tenant application and tenant screening. And that is to conduct case by case reviews. You give the applicant a chance to explain that record, to remain mindful and avoid biases, and then to run Fair Credit Reporting Act compliant background checks, as well as to be aware of clean slate laws that would expunge a criminal record after a set period of time. Another piece of housing that isn't necessarily fair housing but can intersect is occupancy standards. Um, Occupancy standards are usually determined by local governments. Um, Three things that are key generally are the overall size of the unit, the configuration of a dwelling, um, the septic and sewer capacity tied to the dwelling, um, and generally an easy guideline for occupancy is the 2+1 rule. That is to say, 2 people per bedroom plus one extra. So if a dwelling has 3 bedrooms, uh, a reasonable occupancy limit for that is 7 people. So finally, just some global best practices. Uh, as a landlord or housing provider, housing professional, you should treat all applicants fairly, equally, and honestly. Follow the same application and screening processes for every applicant. Never tell an applicant that a dwelling is unavailable for rent when one is, and tell applicants about all available units. A fair housing adherent provider will treat everyone the same, allow housing seekers to make their own choices, and make decisions based on an applicant's behavior and not their characteristics. And these fair housing best practices also look like just good business because that's what they are. If you do have a fair housing complaint, please first move, reach out to a fair housing center. You can make an administrative complaint with the Housing and Urban Development, which is the federal jurisdiction, the Michigan Department of Civil Rights for state jurisdiction. And then, of course, you always have the right to private action, which is a civil lawsuit. And as a final reminder, we here at the Fair Housing Center are not attorneys, and we do not offer legal advice. So this private action needs to be undertaken on your own. And that brings us to the end of this training. We do have some resources here. Uh, the HUD website is a great resource if you want to dig deeper into some of these guidances or some of the legislation that undergirds fair housing. The Fair Housing Act, as amended, the 1988 effective one, is a good resource. The Elliott Larson Civil Rights Act. And then for legal resources, the websites Justia and Legal Momentum have pretty good condensations on relevant casework. And then finally, here in Michigan, we have a landlord tenant guidebook. We here at the center can supply those. Alternatively, an internet search will help you find them. And so last but not least, I would like to thank you, leave you with the contact information, and